This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're now joined by the one and only Todd Lutsky from the law firm of Cushing & Dolan. We get the phone lines wide open for you because we get this is your chance to ask Todd your estate planning questions live on air right now. 888-205-2263 is the number. Again, that is 888-205-2263. And remember, this is your chance to ask Todd your estate planning questions live on air right now. And we usually get through 2 to 3 of these, so get calling early to make sure we can get to your question. That phone number again is 888-205-2263. Mr. Lutsky, how are you doing today?
I am never better, and you?
I'm great.
Awesome.
Where does a king put his armies?
That I don't know. I'm not a king.
In his sleeveys.
In his sleeveys?
Yeah, in his sleeveys. Todd, I want to talk to you a little bit about trusts and trusts as part of an estate plan, as one would expect. At what point does it become beneficial to a household to have multiple trusts as opposed to just a single one for their assets?
So that is really driven by, I think, by the federal exemption. So the federal exemption tends to go up and down, but let's say you have today a $15 million federal exemption. So for everybody listening, that's the amount of assets that you can pass to somebody other than a spouse and not pay tax. Go over that, and of course, we got a 40% tax hit per person. So at a bare minimum, I would say if you're at 15 million or under, I'm thinking that should probably be a joint revocable trust because it's a large estate, but joint revocable trusts. And I think if you're 4 million or below, I don't know if you weren't really asking this question, but if you're 4 million or below, you probably might be considering and over 65, let's say,
sure,
or 60, you probably also might be thinking about whether you want a revocable or an irrevocable trust. But for a joint trust for a married couple, I'd say 15 million is a good number.
At any point in that discussion, are there certain types of estate plans where it may make sense to have different kinds of trusts fulfilling different roles within that estate? Yeah,
so when you get like larger estates like that, sometimes you might have somebody that's got a $12 million estate, let's say, but, a $4 million life insurance policy. Well, that's just an asset that shouldn't be in there. To me, I would say let's just make that asset. Why do I want to increase my taxable estate by $4 million? Maybe not so much for federal, but for Massachusetts, right? Why do I want my estate to be $4 million higher if I don't have to be $4 million higher? How and why? Well, then I would be thinking of a separate kind of trust, probably called an irrevocable life insurance trust, where you might want to take that asset and put it in there, that asset being the life insurance policy, put that into the irrevocable trust, and thereby making it not only income tax-free, which is what it is in and of itself, but also estate tax-free, both federal and state.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. Phone lines are open at 888-205-2263. That is the number to call to ask Todd your estate planning questions live on air right now. We do still have room on those phone lines. Again, that number is 888-205-2263. We're going to take a quick break here, but when we come back, we're going to get right to your questions with Todd. That phone number, again, is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
Got Todd Lutsky here from the law firm of Cushing and Dolan. We do still have room on the phone lines. 888-205-2263 is the number. Again, that is 888-205-2263. Todd, at what point does trust work that someone has previously done turn into a problem if it has not been updated appropriately? Like, what are some of the things that would cause someone to need to update an estate plan?
And I think that's a great question, because so many people who might have already done their estate plan think, oh, I'm all set, I don't have to do anything. Well, no. Again, one, I think if you're 10 years, 15 years in on an estate plan, I probably would say, you know what, maybe I should pick it up and review it. Why? Perhaps my assets have grown significantly. That would be a reason. I'm older, of course. So maybe if I did revocable trusts, I might want to think about changing my estate plan to an irrevocable trust, depending on how large my estate has grown. So obviously, you know, when nursing home concerns weren't an issue, maybe they more are on your mind now. I would say things like, what if I've lost a spouse? You know, even though you've done your estate plan, when you lose a spouse, the problems I've seen are people would say, oh, I got these two trusts and my spouse died. I'll just take everything out of my spouse's trust who's deceased and put it in my trust.
That's not good.
Oh, not only is it not good, it's not permitted by the terms of the trust. But, so someone's breaching their fiduciary duty, number one. But number two, you've now completely blown the estate plan. You've now put all the assets back into the hands of the surviving spouse, bumping up the surviving spouse's estate to a point where it's larger, perhaps, than the exemption that was in effect, or that is in effect, on the date of death, thereby creating an estate tax liability, whereas one didn't exist if you left them in the old trust. So I think that's a really big problem. But that's why you call the lawyer. You call and say, I lost my spouse. What do I do? Please don't call the spouse and call the attorney and say, here's what I did. Is it okay? I always hate it when they start the conversation. Here's what I did. Okay, that's bad.
So this is not a situation where it's better to ask forgiveness than permission.
Right. I think that's a good analysis. So, folks, these are just some of the potholes that we encounter when you have an estate plan or are thinking about doing an estate plan. So this guide is good for both folks, whether you've done the planning or you haven't done the planning. I think it's going to help you. For people who haven't done the planning, don't not plan because you think you have a will and that's all you need. Don't, rely on a nominee realty trust as the only item you have. Don't sit around and think, oh, I don't have enough assets, I don't need to do a plan. Well, there's a lot of other reasons to do planning than just taxes. So, folks, call and get the guide, Estate Planning Potholes to Avoid, 866-848-5699, or legalexchangeshow.com. Again, 866-848-5699, or legalexchangeshow.com. And you can always go to Cushing Dolan PC, our Instagram page, for much more information.
Todd, got a caller for you here. Let's go to Paul in Hanover. Paul, what is your question for Todd Lutsky?
Yeah, good morning. I had a question regarding, I have a revocable trust that was put together about 15 years ago and updated maybe 5.
Okay.
And 65, and I'm looking at, like an irrevocable for the home only for that 5-year look back.
Yeah.
When do you, what's the downside, I guess, of doing something like that other than maybe losing the value of the equity of the home?
So you're 65. Are you married?
Yes.
Kids?
Yes.
Good,
Three.
Last question, excuse me. When we talk about switching to an irrevocable trust or adding one, usually you probably won't need both is my point. But how much are you worth in total, including the house? Meaning, are you more than $2 million? And if so, are you more than 4? Those are the Massachusetts thresholds that I worry about.
More than 4, yes.
So if you're more than 4, the question is, do you really need the irrevocable trust, right? If you've got enough assets, and again, I don't know how much you're worth, but if you have enough assets, you could be self-insured, meaning, if you start adding up your assets and investing it at, say, 6% plus Social Security and pension, do I have enough income coming in that I'm really able to provide and pay for the nursing home anyway, and so I don't need to worry about protecting my assets? Do you think you're in that category?
Close, I guess. I really haven't done the math, but it depends, obviously on longevity there, too.
Sure. I mean, you're going to need to cover about, $125,000 and $30,000 a year, maybe more, from the nursing home. So it's not a small number. And so I think that's the first thing. That's the only reason I'm hesitating on this, but I will address your question. Let's assume you do need to protect assets from the nursing home. Probably if you do need to protect them, you probably might be wanting to protect even more than just the house. You might want to even put some money in. When you learn how they work, because you're asking me about the downside, there really isn't. Other than you can't refinance the mortgage on the house. You can keep the mortgage, but you can't get a new one unless you take it out of the house, start the 5-year clock over again. So other than that, there's no downside. You live in your house, you pay your bills, you can sell your house anytime you want from the irrevocable trust. You can have the trust buy another house. The trust is still set up as a grantor trust, so you get your $500,000 capital gains exclusion. There's no adverse tax consequences when you sell the house. You can manage your money, collect the income. I mean, it's really, I'm going through it quickly, but there's really not a lot of downsides at all. So I think it might be worth exploring, but get a handle on your assets, and then maybe you can decide whether putting more than just a house in is important.
Todd, I got another one for you. Let's go to Steve in Weymouth. Steve, you are on with Todd Lutsky.
Hi, guys. Thanks for taking my call. I was wondering about the $15 million exemption where you don't have to pay taxes.
Yeah.
If your estate is $20 million, do you just pay on the over $5 million, or do you get taxed on the whole thing?
So one follow-up question. Are you married?
Yes.
So if you do basic planning, meaning a revocable trust, right? So in your case, if it's $20 million, we might do 2 separate revocable trusts and then fund those revocable trusts. Remember, they're revocable, so it's just like it's still you, but they're owned by the trust. The reason I'm telling you that is because with basic estate planning, we now can double your exemption. So if you do basic estate planning between you and your spouse, we can shelter up to $30 million from estate taxes. So if you're worth 20, you're not going to have to worry about paying estate taxes, at least not in the short term or even perhaps the long term. But that would answer that question. But let's address your question, assuming that you had, let's say you're married and you're worth $40 million, to just make it the point. And you still did your basic estate planning, which I certainly would recommend. Now we would only have to pay tax on the $10 million that we are over the 40. I'm sorry, over the 30. So, but remember, $10 million. If you live in Massachusetts, it's not just the 40% on $10 million, which is $4 million. You've got Mass, and Mass is over 10%. Mass is close to 16%. So, I mean, you're looking at every bit of 55% total estate tax between federal and state on the amount over. So you would probably even do more planning than basic estate planning if you were in that realm. But if you're in the $20 million realm, at least basic estate planning, and then we can focus on what we might do for Massachusetts. I stress this only because I had a client that came in that was worth about $40 million, not married, but with a significant other for 30 years. And I explained to them that, wow, if you get married, we can save you like $20 million in estate taxes. Yeah, well, whoa. You should see how fast they ran to the courthouse, right? I mean, it's one of those things where they just don't think about it. I get it. You're not married. You know, why ruin a good relationship by getting married? You've been together 30 years, kids from different sides of the relationships. But you know what? Sometimes getting married can make sense. And in this case, it certainly did for them. And it could, well, you're already married, Steve, but not that it could for you, but planning, now that you are married, can take advantage of this doubling of the exemption.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.